Yes, thank you. So today I will talk about the EHEN Working Group on Ethics and Law. So as Eva Ben explained, it is a group that consists of various members from the EHEN cohorts that are all focused on exposome research. This group is very much focused on discussion and exchange of ideas about the ethical, legal, and societal implications that are present in the EHEN project. And so we're trying to develop a joint understanding and position on the ethical and legal issues as they relate to exposome research. So in short, this is about learning from each other and also about an avoidance of having to reinvent the wheel. So the idea is that if someone has an issue that he's trying to resolve, that we in jointly try to look for a solution to this, so we don't have to all on ourselves look for these solutions. So thus far we've had 14 meetings. And as I said, it's very much a discussion forum where a member can bring a case forward, and usually this is an issue that is very much a GDPR or data protection related issue, and then we try and look for very practical solutions to these issues. And sometimes, we come with a very workable solution. Also, sometimes we notice that there is, in some cases, a legal uncertainty that is very difficult to resolve in our group. So to give a bit of an overview of what some of these issues are, I mean, most of those issues can be grouped under one of the following. So first of all, this is about the cross-border sharing of data and human tissue. This is about data shield. Many of the cohorts in EHEN work with data shield, but this then led to discussions about the anonymity of data. We also talked about joint controllers in large research consortia. And finally, we talked a lot about consent, which I will also return to shortly. But just to quickly get back to the focus of this working group. So in a way, we were trying to, let's say, broaden the debate, because the typical LC discussion is very much focused on how the methods of research can respect the rights of participants. And therefore, it has a very much of a tendency to point at all of the dangers of big data research, which then in turn can lead to a very risk-adverse interpretation of the GDPR, which then also causes many issues. So therefore, in a way, we had a bit of a broader aim, because instead of having this very narrow discussion on all of the dangers of big data research, we were trying to put to the forefront the fact that this is fundamentally about a clash of rights, as Ben also mentioned in his talk just now. This is about a clash of rights. And on the one hand, individual autonomy, and on the other hand, what we call the right to health, which I will explain to shortly after this. This is about reframing the discussion on data-driven health research, where you were trying to frame big data research and public health around the right to health. Now, to help you understand what I mean by this, you see here the following picture. So in the center, the green circle, you see the right to data protection as it relates to big data and tissue research. And usually that is what the discussion is about. And it's also usually limited to that. But then around that, you see a larger circle, which is the right to health protection. And around that, you see the red circle is the right to health. Now, the right to health is both the right to health care and the right to health protection. So in a way, what we were trying to do is that show that even the very specific legal discussions are always part of a much, let's say, wider discussion, which is usually, comes down to the right to health, which is also about, what do we want to achieve when we talk about exposome research in a way. And I think the prevailing view tends to be that exposome research should be about contributing to a more just society in a way. So the working group, besides being very practically oriented and looking for very practical solutions to data protection issues, it was also in a way about placing the right to health back at the center of the discussion. So therefore, I would like to highlight 3 specific cases that kind of highlight the more ethical aspects of exposome research. The first one is about social inequalities in the exposome and achieving equity. This is actually a presentation that Sam Janssen gave in our working group, and she's working in Equal Life. And actually, the original plan was that she would present that here, but unfortunately, she couldn't be here. So therefore, I'll give a very short summary of her talk about this. Then I'll also talk about the discussion we had on consent. And the interesting thing about the discussion on consent is that it shows that there's very much an overlap between all of these specific legal discussions and also the more ethical discussions. And I think the discussion on consent shows that they're not actually, it's not that like these are two very separate discussions. They come together quite a lot. And then finally, the consumer cohort, which Frederick also talked about yesterday, of course. But so let me start with the social inequalities and equity in equal life. Before I start, I think the reason that I think this is very important to talk about equity and equal life is that I think it shows what is let's say the prevailing view about equality and equity in a lot of these projects. And I think it is also the prevailing view in our working group. But on the other hand, we do always welcome discussion, and we also welcome dissenting opinions, which is what the presenter after me will go into. But yeah, to just first go into what we mean by health equity. Health equity means the absence of unjust disparities in health outcomes among various population groups, and also about ensuring everyone has a fair opportunity to attain optimal health. And it encompasses both equality of opportunity and equality of outcome. And basically the social determinants of health encompass also the non-medical factors, such as the socio-economic status, education, housing, and what we see is that these factors significantly influence health outcomes. And what we see is that the lower the socio-economic position, the worse the health outcomes tend to be. So how do health inequalities relate to exposures? So what we see is that there is a disparity in access to green spaces, exposure to environmental noise and air pollution, and these all particularly affect populations in the lower socioeconomic positions. So addressing equity in exposome research is mainly about asking how do inequalities in exposures contribute to these health inequities. And so now, how does Equal Life address these equities, address equity? So they do so by focusing on social inequalities in health across the different life stages and through various exposures. And it it examines both the harmful and the beneficial exposures. And they do so through birth cohorts, school studies, non-targeted and also targeted approaches that can then potentially inform evidence-based interventions. Putting equity principles into action would then involve also intervention approaches. So this could be, for instance, expanding access to universal health care, increased childcare availability, traffic calming measures, and also social housing. I think that so if we want to address social inequalities in exposome research, then this equity lens is ultimately quite crucial. And so this discussion on equity also within our working group then led to a discussion about how the other cohorts, how they address equity within the cohort. And for instance, in athlete, we saw that social status and inequalities are taken into account when analyzing the data. And in Eximius, there were discussions on whether to include social class as a factor. And what they saw is when social class is being controlled for, much of the effect of exposure is decreased. But then I'll now go to the discussion on consent. So consent was an issue that many of the cohorts within our working group were dealing with. And this led to many issues. And I think that a lot of these issues can all be led back to the arrival of the GDPR and how the GDPR considerably raised the bar for consent much higher, because consent in the sense of the GDPR is quite narrow, and this has potentially quite broad implications for a lot of these cohorts. In the wording of the GDPR, consent should be freely given, specific, informed, and ambiguous. And now during the drafting of the GDPR, many researchers, they were very worried. They raised worries that in their view, broad consent could potentially no longer be possible. And therefore, during the drafting of the GDPR, they added recital 33. Now, I'm not going to read the entire recital, but it is important here to see that let's say data subjects can still give their consent to certain areas of scientific research. That is what this recital basically comes down to. However, it did not change the wording of consent in the GDPR itself. And also, according to the EDPB, the European Data Protection Boards, and they are very influential in how we should interpret the GDPR, they basically said that recital 33 should be explained very carefully and restrictively. And basically, their interpretation of this recital came much closer to dynamic consent. It is important to note, though, that consent is obviously not the only legal basis. There are other legal bases that then should be laid down in EU law or national law. But when you're dealing with a cohort with volunteers, it is very difficult to imagine any other legal base besides consent. So within the discussions in our working group, we actually came to the conclusion, and pretty much everyone agreed on this, that recital 33 is being interpreted way too stringently by the EDPB. So that was very much a consensus within our group. And we were also thinking about, are there different ways of looking at consent, perhaps different ways of framing it? And we actually came to the conclusion that, and this is also something that the literature usually refers to, that is called consent for governance. And in short, this is a different way of framing consent, where instead of putting an emphasis on what the data subject actually precisely consents to, this is more about consenting to certain obligations. So this is about an emphasis on the ongoing governance obligations that are there to protect the interests of the participants. And this can be done through privacy by design, participant engagement, and also ethical oversight. Now, in the next case that I will be discussing, this will also return this consent for governance. Now, the final case that I will like to go into, and I will not go into too much detail about this because obviously Frederick gave a presentation on this yesterday, so I'll just very, very quickly say this is about, about how consumer food shopping behavior affects our health. And they did so by linking the information on shopping habits through consumer receipts, and they linked these to health data from registries. And this was a way of us looking at the relationship between consumer behavior and contracting or exacerbating certain diseases. So regarding the ethical and legal aspects of the consumer cohort, this was also something we discussed within the working group. And so we looked at all of the, what we saw as the primary challenges of such a cohort. And the first thing that we noted was that basically this is something that takes place in the public-private sphere, because there is a collaboration with a digital receipts provider, a commercial party. And the literature on this refers to as what they call a sphere transgression. So when a commercial party, let's say, transgresses into another sphere, usually the public sphere. Although what we noted was that in this case, actually, it was more the inverse was going on, because the public sphere was actually going into the commercial sphere in order to, make use of all of this information that is being collected in this in the private sphere. However, what we did notice that these kinds of collaborations with a commercial party, they can have a very negative impact on trust. So this is always something to be mindful of. Then we also looked at consent, and what we saw was that the way that because the cohort was the legal basis was consent for the collecting, the linking of the data. And we saw that consent was formulated in quite a broad manner. And this was actually, the Danish Data Protection Authority was okay with this. And we also didn't really see an issue with this. But as I said, the EDPB is very strict on how to view broad consent. So this was also potentially an issue that we saw. And we also saw that the way that the consent was organized here, in a way it was, let's say, a more rudimentary form of the consent for governance that we also talked about in our working group. And we saw that they were actually, basically on the right track of organizing this consent for governance. But we did say that perhaps the participant engagement could, be slightly better than it was. And I think they made a few changes on this. But the effect of this, because in going for this participant engagement, or this, let's say, enhanced engagement, it was also about putting to the forefront the fact that there was, a collaboration with the commercial party, and to some potential participants, this is a reason for them to say, no, we do not want to take part in this. So sort of like an issue you go into is that, you want to do this in an ethically the ethically right way, and then going for more engagement and also explaining all these things. But that can then in turn lead to participants saying, well, this is not something we want to take part in. So that is a bit of a dilemma, even though we do think that it is ethically the right way of going about it. And then the last thing we noted was that relates to the real world implications and outcomes of the research. And what we talked about was that one thing that could still be done maybe better is to talk about how the outcomes of this research can then inform certain policy decisions. So certain decisions on public health that can then for some participants also be seen as very paternalistic, for instance. So that was, some of the ethical aspects of such a cohort. So concluding, so many discussions were actually left out of this presentation. We also talked a lot about developments in EU law, such as the EHDS, the European Health Data Space. We also talked a lot about governance, but today there will be other presenters that will go into those subjects. And another point was, what kind of tangible results has this group brought forth so far? And I think it is important to notice in this aspect that mainly this group was about a discussion forum where discussions could be freely had. So that was the main focus of our working group. However, we did lay the groundwork for certain possible common standards. For instance, a model for joint controllers to discern which party is or is not a controller or a joint controller. We also talked about the 6 safes model, which is a model, it is basically a risk assessment of discerning whether a data set contains anonymous data or not. And also, as Eva Ben also mentioned, there will be one big report that summarizes all of the discussions in the working group. So, thank you.